hold on to what we can hold on and leave what we cannot. And so I was expecting that our members of the appointments committee will literally get along, vet the honorable nominee, and then we can deal with the residual issues. It's not, I don't think it's a good experience to make Parliament look like a place where, we are not valuing time. After 2 hours, we have nothing to show for it. Time is a resource that you can never get back. There are many of us here who would have utilized the last 2 to 3 hours. So that is my greatest worry, that things have to be done and they have to be done. There are times for other things. And so the attempt to literally turn the appointments committee into a minority forum, for me, I think it's not on. It's an appointments committee. We must stick to the rules. And if you have the leader, the majority leader, he indicated that the privilege of allowing a member to offer some preliminary statement is not a right. It's just something. So if we tend to abuse it, what it means is that we might lose that privilege in future. So I'm hoping that they'll be back on time, and then we'll get it going. I believe in the president's nomination. I know due diligence was done to settle on Justice Baffoe-Bonnie, and we're looking forward to a renewed Supreme Court once he's confirmed that his conduct, his work will bring back the confidence that we all had in the Supreme Court.
Great.
That is what I'm looking forward to.
Thank you so much.
You.
So that has been Honorable Zuwaira Ibrahim, a Member of Parliament for Salaga South, also her views on what has transpired and what it is that has unfolded over the past 2 hours or more. Let me see, maybe I can engage this Member of Parliament also to get his view really on all that has transpired. Honorable, can I get your thoughts briefly? Briefly, you have observed. Okay, that is fine. So I'll get him in a jiffy to share his views really with me. But that is what it is that has transpired so far. A process that was expected by many to be as smooth, unfortunately hit that stalemate over all that we've told you about the background story, which you're very much aware of, as it were. And now we are on a break. It is the reason you don't see the vetting happening. The chairperson, Bernard Ahiafo, called that there should be a break to allow cool heads to prevail. And then after that, we will be back with the rest of the process to follow or to continue. And so that is it. Very soon, indeed, leadership, and especially from the majority side, is still around. Indeed, I see the Honorable Mahama Yariga still engaging the guests who are still seated patiently, trying to get their thoughts. And so I will seek to get briefly some words from another Member of Parliament, just on his expectations and how things have been over the period. So Honorable Zedin, Member of Parliament for Laura, joins me right now. Just some quick chat with him, and then we are good. And so, just briefly, you have observed the proceedings so far. What do you have to say?
Well, thank you very much for the opportunity. Honestly, I'm very much disappointed about what took place, because basically we have come here to vet a nominee, and our business should be how we are going to carry on with that particular responsibility. And you have a minority leader who introduces extraneous matters which have nothing to do with the vetting. And so I'm disappointed about that, because all that he's saying, there's an opportunity for him to say that, and he can do so if he organizes a press conference, and then he can have all the time to do that. If he wants to spend 3 hours, that is his cup of tea. But no one will come to do this important job of vetting a nominee. I don't think that is right.
So I would say he has his right to air his reservations or his views.
He has the right to air his views, his reservations, by asking questions. That is what he should be doing, and not say that he's coming to make preliminary comments and spend 2 hours making the preliminary comments. Why? That's not a right. Every right must be exercised with responsibility. You don't have to abuse the right that you are exercising. It's a complete abuse of the process.
Thank you so much. So that has been the Member of Parliament for Laura, Zidane Anwanta Zumo. He's the MP for Laura. He's also shared his views on all that it is that has transpired. See, Alfred, that is all that has played out. And I know that you know all the details thereof. And so we are waiting patiently when this is called to session. When this vetting is called to session, we'll be back to bring you some more updates on all that it unfolds. And as it were, TV3, we are going to carry everything live throughout. And already, when you get to our socials, we have all of those clips and quote cards and the rest of all the key items that took place earlier. And so you can still keep yourself abreast of the issues. Alfred, you and the team can take over. We'll be back when we are back live with the vetting.
Right on. And Christian Yale, they're live from the Appointments Committee sittings, and we'll still continue the coverage of the expected vetting of the Chief Justice nominee. And it's just on a break because of the hiccups that we saw that characterized the early part of this process. But here's what we do know, that all things being equal, this vetting will proceed in the coming minutes ahead of us. So we're there for you here on TV3 and also on 3FM 92.7. And let's go on to the telephone lines right now. Let me just acknowledge the presence of Kweku Ansah-Sarry, a former director of the Ghana School of Law. Also, we still have Christian Mamhesi, he's a private legal practitioner. Professor David Abdullah is a governance expert. And then also an executive director of the Africa Center for Parliamentary Governance, and he's also been contributing his thoughts and views on the issues playing out right now. Quite a number of people are at this particular Appointments Committee to witness the vetting of the Chief Justice nominee. And Marietta Brewer-Piopong, a former Attorney General of the Republic of Ghana, we saw her there in a chat with that's the Majority Leader, Mama Yariga, right behind Christian Yale. Now, Kweku Ansah-Sarry is on the telephone. Ansah-Sarry, thank you so much for joining us on TV3. Hello, Mr. Ansah-Sarry, can you hear us? Hello, Mr. Ansah-Sarry, we'll try to reconnect with Kweku Ansah-Sarry shortly to get his thoughts on what has transpired so far. He is actually at this vetting, the venue of the Appointments Committee, where this vetting of the Chief Justice nominee is taking place. So he has a fair view of the interactions even outside of what we are seeing on television. And so we'll connect with him shortly. Christian Mamhesi is connecting still with us here on TV3. Counsel, now, there's been a number of things that Mauna has established with you. One of the issues you see quite clearly is that, as expected, the Chief Justice nominee has a solid support and the backing of that's the justices of the Supreme Court. Not because of his current portfolio, but also having served as a senior most over the period. In fact, being appointed onto the bench sometime in 2008, he comes in with some experience, is it not, that would then galvanize that kind of support and the backing of all the other justices of the Supreme Court. How do you expect that camaraderie to play out if and after he is eventually approved by Parliament? If you could unmute for me.
He comes in with a wealth of experience. I mean, from when he was appointed to the bench under the tenure of
that's John Ejekwu, yes.
And he has risen through the ranks. He has risen through the ranks to the highest or the apex court. Indeed, being the senior most would definitely come by experience and also career progression. And definitely through that, he would have definitely courted the confidence of his peers. That is the reason why you are seeing his peers around him to shoulder him through this particular vetting. And definitely, once he has existed in that particular position for all this while, there will definitely be that relationship built. And also, I mean, in developing the jurisprudence of the country as far as judicial precedent is concerned. And so he comes in with a wealth of experience, and it is our belief and hope that given how things have turned out, he will definitely shoulder and direct the judiciary to the pinnacle of justice that the masses expect. Because just as we know now, or as the law prescribed, law emanates from the people, and definitely that is what Parliament is seeking to do. That Parliament is a representation of the people, and it is deemed as the people through Parliament are the ones vetting the honorable nominee or the justice nominee, so that when he assumes the position, we would see a more robust judiciary, a judiciary that will deal more with its administrative bottlenecks, a judiciary that will have infrastructure partnerships with deepening relationship with local governance institutions, because the district assemblies and the municipal assemblies, they are supposed to be working with the judiciary so to develop district courts and other court infrastructure across the country. We are seeing that poor development, or we've not seen much in that area. And it is our prayer that we are going to have such relationships developed to ensure that justice delivery is enhanced. We are also going to see that most of the courts are going to have are going to have the presence of judges more, because we have experienced situations where in some courts for whether promotion, which hitherto should have been anticipated by the judiciary, have not been catered for, and that has caused the absence of judges in those courts. And when that happens, it's either there will not be substantive judge to hear the matter, and creates expensive litigations. I mean, I'm a victim of that. That's why I'm saying that in a number of cases that I'm involved in, especially this new legal year, we've had the incidence of that. And where there's a relieving judge, that person probably comes once a week. And when that person comes, we would only want to deal with few cases that he or she could handle. And so all of these administrative bottlenecks exist across the country, and it is our prayer that we are going to have His Lordship deal with most of these things, so that justice delivery would be more accessible and less expensive.
Well, and you see, all of these challenges that you outline, quite telling in terms of its impact on justice delivery, because you are an officer of the court. You know the realities in terms of the bottlenecks that impact on the justice delivery system in this country. That's why you talk about all of these administrative issues and so on. I do know that there's been some, digitization interventions and so on. There's software that were purchased to address some of these bottlenecks. The last time I checked, this software that was purchased, thousands of dollars, it's not being utilized to its optimum, expectation. So what's going on? You're an officer of the court. What's happening?
I mean, again, thank you. I mean, with these softwares for filing and all of these, this software basically exists just within Accra. And even in Accra, it's mostly concentrated at Central Accra. At the court complex, you have it functioning more. If you move to certain parts of Accra, you don't have this this software so-called existing. Indeed, even other parts of Accra, just travel down, going to Weja, going further down. I mean, there are some of the circuit courts without computers, and I wonder how we can only pray. Let me withdraw that. I wonder how we can only pray that there will be a hands-on on the administrative aspect, because the administrative aspect of justice complements the real justice that is dispensed in the courts, and that is what should be enhanced, because it has made practice quite difficult, more especially if you would have to travel all the way to say Kufuridua or Hu for court. If a judge is not sitting, you would not know unless you get there, and chances are that if the court clerk is magnanimous and there has been a creation of a WhatsApp group, that notice will be put in there. But even with that, the notice could come in, and then the very 11th hour, you'll be told that the judge is sitting, and you'll be left out, and you'll be forced to take a date, and that will be more cost to the client. And when you're explaining that to the clients, they just can't understand it. They think you want more money from them because transportation, they have to pay under the Ghana Bar Association scale of fees and the incidental cost. They have to pay transportation, which is devoid of the legal fees. So the scale of fees enjoins us to explain that to them before commencement of work, and also to sign legal service agreement. So there are always two costs that they pay: incidental cost and then the legal fees. So when these administrative bottlenecks are dealt with, it is going to help a lot. And if we have these serious problems in Greater Accra, you can imagine the hinterlands.
True.
So it is for me, the administrative aspect is very, very important, and I pray that definitely, as the incoming Lord Chief Justice, we pray that his attention will go to that aspect, so to make the work not just at the bar, but justice delivery across the country very, 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 very accessible, and it would also make it less expensive when we have expedited cases happening. Again, talking about expedited cases, because of the poor implementation of the software, or the less expansive reach of the implementation of the software in other areas.
In fact, it is that point that I want to hold you on to.
It has also affected.
I want to hold you on to that point about the cost of the implementation, because then again, you mentioned how that is also impacting on the cost to the client. So hold on a bit for me. Alhaji Yunus Afuseni is a former member of parliament for the Tamale Central constituency, former Minister of Lands and Natural Resources. He's also held a number of portfolios, serving as minister to contribute to the development of this country in many ways. He's a private legal practitioner in good standing. Alhaji, good afternoon. Thank you for joining us. Hello.
Hello.
I can hear you.
Yes, I can hear you. Thank you for having me.
Great. Now, if you haven't been watching what's been happening so far, the appointments committee, just summarize it for you. The minority leader raised some objections and concerns, and which has led to a temporary break in the vetting of the Chief Justice nominee. Although this was expected, that is, either they walk out or they come in and make their case about some of the concerns that they had raised prior to this moment concerning the removal of the former Chief Justice, and then also how Justice Gabriel Scott Palman, as well together with the other members of the committee, conducted their work. Now, with this hiccup that has been experienced, which has led to this break, how does all of this strike you, especially because it is also impacting on the vetting of the Chief Justice nominee as we speak?
Well, thank you. I think that what is happening is very, very unfortunate, and it's marked of some level of indiscipline on the part of members of parliament.
Why do you say so?
Because the members of parliament exercising their rights under parliamentary procedure filed a motion with the speaker. That motion came before the speaker, and the speaker ruled on that motion. So that matter has been settled. And you cannot go back to the vetting and seek to raise these matters which you tried to raise by motion and which was rejected. And it's marks of some level of indiscipline on the part of the minority in trying to do that through the back door.
Why do you describe their process of letting their own reservations and grievances be known as an act of indiscipline?
Because they have invoked the procedure under the parliamentary rules to have their matter heard on the floor of the House. There is if you want, a winnowing process for the receipt of motions or admission of motions. The motion came before the Speaker, and the Speaker, in his view, thought that the motion or ruled that the motion was inadmissible. That should end the matter. That should end the matter in the sense that because they invoked the lawful procedures of Parliament and the authority of Parliament that has the power to decide whether or not the motion was proper before the House, ruled otherwise. To come back and raise the same matters or try to raise the same matters at a committee hearing can only be described as indiscipline.
I see, but then how else or which other process could they have employed to still let their grievances be known or their reservations be known despite
so when the Speaker, there's a rule of Parliament which says that if a person disagrees, if a member disagrees with the ruling of the Speaker, he files a motion challenging that ruling. There's a rule of Parliament. So it is not like, there's no remedy to that ruling. There's a remedy, and the remedy is that you file a motion challenging the ruling of the Speaker.
But then again, that would have been after the fact. That would have been after this vetting. And they thought that this was a prime opportunity to still state their case, even before the vetting.
The fact that you do not have the time to do that does not justify using illegitimate means to bring your concerns to the floor of the House through the committee.
See, now this has led to this vetting process being truncated, at least temporarily. How do you expect the chair of the appointments committee to handle this after this break?
Well, when the word was used, the leader of the House ought to have, of the committee ought to have called upon the majority leader to withdraw that word. And if he refused, could expel him from the meeting, could get him to leave the meeting, because that would be insubordination to the authority of the chair of the committee. And so this ought to have been the procedure. You should have gotten him to withdraw. If he refused to withdraw, to get him to leave.
It's two things. They didn't ask him to withdraw. They've gone through this process of going for this quick recess. It's a stalemate, yes. But then again, two things may happen after this quick recess. It's either the minority would come back and still take advantage of this process to state their case, or they would walk out of this vetting process. How do you expect both to play out, especially when it comes to the majority or the chair of the committee handling the process, if these two likely events take place?
The best way out is to use the parliamentary processes. The parliamentary processes safeguard the minority from the arbitrariness of the majority, and safeguard the majority from the tyranny of the minority. All based on the parliamentary process. So if you don't follow, or if the committee fails, refuses, or neglects to follow the parliamentary processes, that stalemate will persist. The majority or the minority will have its say, consistent with the rules of parliament. If what they say is not consistent with the rules of parliament, there are rules in the standing order that deal with any matter that is unparliamentary. And they must learn to invoke such provisions and such rules. If the majority decides that the minority should not speak, there are rules of parliament encapsulated or found in the standing orders that protects the right of the minority to speak at such committee meetings. So the best way out of a stalemate is to go back to the rules of parliament, the standing orders.
I see. Now, hold on a bit for me, Alhaji Yunus Afuseni. Kindly indulge me as Professor Abdullahi. You hear Alhaji Yunus Afuseni talk about the chair of the committee safeguarding the sanctity of the process from the tyranny of the minority. These were the words that he used. I mean, has the chair of this committee, Donald Bernard Ahiafo, been able to assert the authority that this position gives to him in implementing the exact rules of the House and the standing orders as expected, that would be able to preserve and protect the sanctity of the process from whatever disruptions that would come?
Well, first of all, I think he has not asserted his position enough, because by asserting his position enough is to be fair, but also it should be within, the standing rules of Parliament. And I think he has tried. I think he's been on similar committees with the minority leader, and he has tried at least to give him an opportunity to come up with his views and so on and so forth. Except that, it should be within the law. It should be within the standing orders. If definitely he is to assert his position, I think he should make it very clear that, if you repeat X, Y, Z, I'm going to make sure that I let the rules pertain. So I think Alhaji was basically, as a former member of parliament, is actually telling you that each, either the minority or the majority, each and every one of them have rights as well as responsibilities in performing their legal duties as parliamentarians. But if one particular, if the minority or the majority is trying to capture, the hearing in a certain way, the chairperson must make sure that they assert their, their chairmanship without any doubts, and it should be right on. And if any of them then see it not in their liking, then of course they have the option, either that the chairman lets you leave, or you can leave by yourself. But I think at the end of the day, what is very important is that I think, Nene, we have seen this before, whereby the minority speaker in committees like that had actually always gone off point. I think there was a case he asked one of the, the nominees to sing, and he has asked even the current, Deputy Attorney General to dance, and all those have nothing to do with vetting. It is basically to make sure that the person who is vetted is qualified, has the requisite credentials, has the experience, and is going to dispense, justice and fairness in their position. And I would employ the appointee that, as I've always said, that leadership is not a popularity contest. I think he knows that when he goes in there, he's not in Hollywood. He's going to make sure that he delivers. And by delivering, the previous guests on the show have already talked about the challenges that we are facing in our judiciary and the delivery of justice in our system. So definitely he must go about the challenge of managing, making sure that our courts work efficiently and thus deliver justice. I also think that at the end of the day, having his experience and having been so, he's been on the Supreme Court as someone who's now the most senior of all, should apply that in such a way that he brings all of the people along, because some of them will not support him. And those who will not support him doesn't mean that he shouldn't bring them along, because he's going to be a Supreme Court justice if he's approved for not only his colleagues, but also for the whole of Ghana. And I think at the end of the day, that is what we want, so that our democracy can move forward. And at the end of the day, we must always remember that we're a developing country. Even the developed countries, they have challenges. And those challenges doesn't mean that they cannot move things forward. If you look at it right now, even at in the US, the Congress, they are at a stalemate, whereby the Republicans and the Democrats, have shut down government. But at the end of the day, they have to talk together and make sure that it's taken care of. So I believe that Alhaji was saying that the chairperson, when they come back from the recess, must be very, 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 tough on the rules and make sure that the processes move forward, so that at the end of the day, we are able to come up with the approval or whatever of the nominee.
See, Prof, and stay with me a bit. And Alhaji, are you there? Can you hear me?
Can hear you.
Perfect. Do you align with this thought process and the position that Professor David Abdullahi espouses, that Bernard Ahiafo has not asserted his authority that much as expected as chair of the committee, even though the powers and the standing orders does give him the power to ensure the sanctity of the process without necessarily having it get chaotic?
Well, I have worked with Bernard Ahiafo when I was in Parliament. I know him. He knows the parliamentary rules. He's a forthright person, but he's a team player. He wants to move everybody along. He wants consensus to animate the process, and so he always plans backwards to accommodate his colleagues on the committee. And we saw that during the vetting of the appointment of the nominated ministers of state. So I think that's his style. Many people were not impressed with his attempts to bend backwards to accommodate his colleagues, and particularly the minority leader. But these as is may, I know Bernard Ahiafo, and I know he's a forthright person, and I know when he comes to the conclusion that his efforts are not being appreciated and reciprocated, he will take the necessary decisions.
I see, and that leads to the next question about how, going forward, you would expect the sanctity of this process to be preserved. What should he do? As you say, you know him.
The consensus is that the standing orders must animate, regulate, and inform the way a committee of Parliament performs its functions. If what a member is doing cannot be found in the standing orders of Parliament, that committee, that person will be out of order. That member will be out of order. And it is for the chairperson of the committee to so say. And that chairperson, the chairperson of the committee, and particularly the appointments committee, has enough powers under the standing orders to deal with any recalcitrant member who is determined not to follow the standing orders of Parliament. And so I believe that Bernard Ahiafo, who is the first Deputy Speaker of Parliament, is quite aware of the enormous powers he has as a chairperson of the Appointments Committee, and will demonstrate that authority if the need arises.
Alhaji, and before I let you go, let's come to the man on the hot seat now. I'm talking about the Chief Justice nominee, Justice Paul Baffoe-Bonnie. It's a man that you may have appeared before him. I mean, he's served at the Supreme Court bench for almost 18 years now. You know, for the politics of things, I mean, he comes in with that kind of united force, is it not? Having been appointed by the former President John Agyeku Kufuor to the Supreme Court, and he served all throughout to this moment when he has been nominated as acting and now the substantive Chief Justice nominee. If approved, he's going to have just about a year to serve as Chief Justice. What are your expectations of him?
So a year is enough time for the Chief Justice to bring some sanctity, respectability, and dignity to the bench. By just putting in rules and procedures that clearly would animate what the court does. And so yes, he has not much time on the Supreme Court, but then he can do a lot to ensure that the instability that has characterized the Supreme Court of late it becomes a thing of the past.
Yes, and I appreciate it. He's a former member of Parliament for the Tamale Central constituency and a former Minister for Lands and Natural Resources. As you just saw on the television, we're going back to the Appointments Committee right now because the Chief Justice nominee, Justice Paul Baffoe-Bonnie, has resumed his seat, and the members of the Appointments Committee are also resuming their seat. The vetting process is going to resume shortly. And as I did indicate to you, that we have quite a number of the justices of the Supreme Court present. You saw there Justice Gabriel Scott Puaman, who was the chair of this 5-member committee that was established as per the dictates of Article 1469 of the 1992 Constitution of the Republic of Ghana, that had the petitions, and then also gave the former Chief Justice that opportunity to also have her say and respond to those petitions, and eventually, based on the findings, made a recommendation, and then also said Justice Dennis Ajay, all of them in there as well, Justice Napari Batels as well there, Supreme Court Justice. Let's cross over to the Appointments Committee right now. The chair of the committee is just putting measures in place and dictating what has to be put. Let's hear from Alexander Penyumakin, who is talking now.
Whilst there are pending cases by the leadership, Justice Arthur we as part of the
So we'll rectify the connection to the Appointments Committee shortly, but that is Alexander Penyumakin, the minority leader, the Futu Member of Parliament, who is making a statement. Let's cross over right now to hear from them. They're making their position clear on the concerns that they had already indicated surrounding the removal of the former Chief Justice, Justice Gertrude Araba Esaba Saki Tokono, and the reason why they had taken that position and how that is going to inform their position as well on the committee, the Appointments Committee there in Parliament. We'll cross over shortly to hear from Alexander Penyumakin, who is making a statement right now at the Appointments Committee, whether or not they will continue to take part in this process.
My Lord, Justice Baffoe could continue serving in acting capacity until the court have provided clarity on whether Her Ladyship Justice Araba Esaba Tokonu was lawfully removed. In our view, all that is happening does not amount to some objectivity at play. We rather see a fait accompli. Chairman, it is also our view that for the sake of our country's democracy and rule of law, the grant of 3 weeks extension for the learned Attorney General for leave for extension of time was rather unacceptable after the long delay in filing an opposition.
Chairman, please, Chairman, this has to be withdrawn. This has to be withdrawn.
We won't listen to you. Chairman,
please, we heard what he said. You clearly, you can't sit here and malign a decision of a court. It's not acceptable. It's not acceptable. Please, don't let us keep doing this, and then send the impression out there we are bad people, we are a minority trying to prevent you from. The rules are clear. You've been told the rules severally. Please.
Chairman, I'm sorry. I think that Chairman, we have to help you. With respect, we have to help you. My leader speaks at will. He speaks at will. We all know the practice in this house. Leader, you have to catch the eye of the speaker. You have to respect the chair. This attitude of suddenly punching the microphone and speaking, you are our leader, but you are a member of parliament. You are subject to the same rules as apply to all of us. So, Mr. Chair, I think you should have a word with our leader.
Thank you very much.
Your consent.
Honorable Minority Leader, be guided and candidly land safely. Yes, Honorable Ayarga.
So I raise an objection to his reference to a judicial decision and the conduct of a judge. And the rules are very clear. I really don't understand why the minority leader wants me to keep reciting the rules. Because everybody knows that the rules are clear. You can't say that about a decision of a court. You can't say that. So you have to expunge that.
Honorable Majority Leader, I have heard you. Honorable Minority Leader, be guided accordingly. And proceed.
Chairman, with respect, what we are saying is that we disagree with the said decision of the court. And it's our right to have a disagreement with the court, most respectfully. Especially so when we are of the view.
You see, Honorable Minority Leader,
Chairman,
you can disagree, with all due respect, with the decision of the court. And when you disagree with the decision of the court, you know how to do.
That's not a problem. But we are making a comment, Chairman. Chairman, I've held my calm throughout all of this. I gave you my word, proud to this verdict, and I've kept my word. Today in Ghana, you cannot even speak as a parliamentarian to express a view. You will be stopped by the majority leader. I am not attacking the court. I'm saying that the minority disagrees because we have the rules book, the CI 16. When you apply for extension of time, there's a time period. You can't go beyond 2 weeks. We have the provision, so we cannot disagree with the court. We cannot cite the court own rulings and say on this we disagree. What is happening here? Because somebody has super majority? What is happening in this country?
Minority Leader,
what have we done wrong?
I will not have a problem.
I have not attacked any judge. We've not attacked the court.
By way of a question that will give an opportunity for a response. You are making a preliminary comment.
Exactly, that's exactly what it is. That's exactly what it is.
The rules.
I don't have a problem.
Make your preliminary comment as such.
Very well. Chairman, thank you. So we expect that steps be taken by the court to expeditiously hear the cases brought before it by the respected, learned Justice of the Supreme Court, who until removed was the Chief Justice, Her Ladyship Gertrude Araba Isaba-Togo. Expeditious hearing of this matter and a final determination of this matter will reassure the Ghanaian public that the rule of law works, that we respect the Constitution. Chairman, we submit further that all the delays in the filing of defense in the matter is a strategy. A strategy to ensure that these cases languish undefended, creating space for this right competition to proceed.
Yes, Honorable Ayarga, let me hear you.
Why?
Now and then, the minority leader will say that we are politicians and we should be allowed to do politics. Yes, politics. But when we sit here, our politics should be guided by rules. The rules are very clear, Chairman. The rules say that where in the opinion of the Speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives. Impute improper motives. I repeat again, impute improper motives or impugns the integrity of a member or any other person. The Speaker may order that the member withdraws those words or withdraw and apologize. The Attorney General is a constitutional office created in our Constitution, and he is a member of this House. In the discharge of his functions, you have no right to come and sit here and impute improper motives. Our rules are clear. What you are saying, you are imputing improper motives. Saying that all of it is a charade and then a strategy and etc. to subvert justice. No. Mr. Speaker, how can he say that? I object and I insist that that part of his statement should be expunged. And the rules are very clear. That any reference to the conduct of persons mentioned in Rule 7 in any amendment, question, or remarks in a motion or on a debate dealing with any other subject is out of order. And then you, the Speaker, or the 123 Rule 3 says that if you make a determination that indeed he has impugned improper motives, you should order him to have it expunged from the records. And I'm saying that he has impugned, imputed improper motives, and therefore he should expunge that from the records.
Yes, Honorable Minority Leader. Mr. Chair, Honorable Minority Leader, please put off your microphone. Please put off your microphone. Yes, Honorable Minority Leader, you have the floor.
He's a member. Mr. Chairman, some of my, yes, sure. I'm saying that my colleague has a point to make. Since a point of order has been raised, I think that it was within every member's right to respond, not limited to only me.
Well, Minority Leader, with all due respect, we are a house governed by rules.
Sure.
I can be guided by the rules that enable the Speaker or the person presiding to take a point of order against a point of order or a response to a point of order from any other person apart from the person who raised the issue. So the rules are applied. That is why I asked the honorable member to put his microphone off, and then I'm giving you the floor to respond to the issue of the point of order raised. On the response to the point of order being raised. Yes, Honorable.
Yeah, Mr. Chairman, I have been quiet since morning, and I think that we must be serious as a committee. Mr. Speaker, I should think that some members of this committee have a preconceived mind, either to object to every word, every letter that is said, and we cannot continue like that. You being the chairman, Mr. Chairman, I pray after the break, Mr. Chair, you have to steer the affairs of this committee. Now, the majority leader, let me, please, I have the floor. The majority leader is not about, but if you are quoting the standing orders, that people are imputing improper motives, you must go to the extent of proving to us that this word is an improper motive. You just don't say it. Now, even the law that you have cited, it's on motions. What motion are we dealing with here? Now, every committee ever since I became a member of this house, every committee meeting, people, we start, the chair, the ranking, we come out with preliminary issues before we start the agenda of the meeting. Now, if you raise the question about what I heard other people say that, well, there had been issues, nobody has the right to raise a preliminary issue when the chairman already ruled that he should speak. This is part of us. And if every word is going to be objected to, then I don't think that we are ready for the vetting. Now we have been here all day. The nominee had not even spoken a word.
Honorable,
this objection, that objection, and
Honorable Entry. You raised a point, but I feel you are out of order. It's not in response to the issue on the floor. So, Honorable Minority Leader.
Chairman, thank you. Oh, very well. Chairman, nowhere in my submission did I impugn improper motives, or was there an inference to such an act? Chairman, you must let the majority leader know that he is a majority leader. When you raise your objections and everybody is quiet, and you are so intolerant that you want to find a way to create chaos, I won't give you that. No, Chair, he was just talking. No, but you are closer to him, Chairman. We've all kept our calm. He is showing power, force. I am this, I am that. It's not fair. What he's doing is not fair. It's not fair.
Chairman, what the rank is doing is not right. You were given 5 minutes. We spent 15 minutes.
Have the floor. Honorable Dafamako, you don't have the floor. Honorable Roxanne Nelson Dafamako, you do not have the floor. You don't have the floor. Please, Minority Leader.
So, Mr. Chair, we've been very calm, quiet, decent. We want to discharge our parliamentary duties, yet the attacks are becoming one too many. Now, let me respond to him. I stated the fact that cases were filed as far back as May. It was only recently that the AG filed a motion for extension of time to file a defense and sought the leave of the court for that. It is a matter in the public domain that long after the time required to file a defense in that important constitutional matter had lapsed, the AG had not filed,
the court itself had not issued a hearing notice to compel the AG to come to court until the AG applied to the court for leave to file out of time. It is a statement of fact that we as the minority are raising as part of our concerns regarding the constitutional overreach. We are not saying anything less apart from what is in the public domain. So, Mr. Chairman, the majority. I have my speech before me. I can read it again. You see?
Honorable
Chairman.
Leader.
Chairman.
With all due respect, can you conclude? If I will have to rule on the objection raised, this is what I will say. We have a constitutional mandate to vet the Chief Justice nominee. The issue before the courts, whether a defense has been filed, leave has been sought, defense has not been filed, is a matter entirely in the domain of the courts. And this cannot be a subject matter of discussion at the vetting committee. Consequently, everything said about defense or relating to that is ordered to be expunged from the record. Minority Leader, please proceed.
Chairman, with respect. Chairman, with respect. Chairman, with respect. You are not doing justice. And I say so because everything that is happening here appears to have been well rehearsed by the majority leader with a view.
You see, Honorable Leader,
Chairman,
you have been a majority leader
Chairman,
before.
Chairman,
becoming a minority leader, there is nothing that is well reserved.
Chairman, this approach where you come, force you, speak, put on the mic, then you say it is expunged. What exactly, what particular word are we expunging?